Hello and welcome to the first edition of our weekly Senzo Meyiwa murder trial wrap. I'm Mnisi. So it's been 9 months since the trial into the murder of soccer star began in the Pretoria High Court. The state has laid extensive evidence on what it believes transpired in October 2014 when the former Bafana Bafana goalkeeper was gunned down at the phosphorus home of his then-girlfriend Kelly Khumalo. Several witnesses took to the stand, including 3 people who were in the house during the murder, neighbors, ballistic as well as forensic experts. So what do we know so far? That 5 men are now on trial for Meyiwa's murder. They are Mnisi, Bongani Ntanzi, Mthobisi Mncube, Mthokoziseni Mapisa and Fisokuhle Ntuli. The state believes they shot Meyiwa during a botched robbery and has charged them with murder, attempted murder, robbery with aggravating circumstances, possession of unlicensed firearm and ammunition. The 5 suspects were charged under docket 636, led by investigating officers Brigadier Bongani Gininda, Sergeants Vusumuzu Mokhane, Batu Mohola and Stephen Mabena, who is now late. Judge Rata Mokhwatleng has been presiding over the trial since July 2023. He replaced Judge Chipiwa Maumela, who was unwell and who was suspended for alleged failure to deliver judgments timeously. On that fateful night, several people were in the Khumalo home when the gunmen allegedly stormed the house, demanding cell phones and money and later pulling the trigger. Occupants include singer Kelly Khumalo, her sister Zandi Khumalo and then boyfriend Longwe Twala, their mother Gladness Khumalo, Meyiwa's long-term friend Tumelo Madlala, and childhood friend Mthokozisi Twala. Well, nearly a year later, the wheels of justice may be turning slowly in the Senzo Meyiwa murder trial, but they're grinding. A trial within a trial had its fair share of twists and turns over the alleged confession statements of accused number 1 and 2. Judge Rata Mokhwatleng ruled that the confessions made by Mnisi and Bongani Ntanzi are admissible, clearing the way for the main trial to resume.
Careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2 and the cross-examination interposed by the state, and after careful analysis of the heads of argument by all the parties concerned and the verbal submissions made by all the counsels in this court, I have dealt, not like this magistrate did, I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. It's reached the following conclusion. 1, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Ronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2. Freely and voluntarily without any coercion when he was in his sound and sober senses.
The trial into the murder of former Bafana Bafana goalkeeper Senzo Meyiwa kicked off again on Monday, the 15th of April. After a 3-week recess, the Pretoria High Court turned its attention to state-led crucial evidence on the recovery of cell phones from 2 of the accused in prison. The devices were found while the accused were in custody in 2020 and 2021 respectively.
Then ngavula abafana babo 3 not angisho abafana bangibedelela kodwa sibabiza ukuthi abafana all ama-male. Ngase ngithi ke lona engangiphethe camera ngase ngithi letha i-cell phone.
And who's this person that you were talking to?
Ulwazi angiphethe igama likaFiso kuhle Ntuli.
Is he in court?
Yeah, ukhona.
Yes, can you?
Ngilapha egcineni.
It's accused 1 up to 5.
Oh, number 5.
Yes. You may proceed.
Ngase ngithi akanginikeze i-cell phone, akazange ngihluphe wanginikeza i-cell phone. Ngase ngimtshela ukuthi i-phone ngiyayithatha ngoba avumelekile ukuyiphatha.
Where was this phone?
Yayi lapha angithiwa basebelele esembhedeni wayikhipha lapha embhedeni lapha ayile khona wanginikeza. Ngase ngivala i-cell ngabuyela ngenyuka ngaye office. Ngase ngiba nengxoxo ke nomphathi ukuthi le ndaba yale cell phone ayingihlali kahle ngoba angazi ukuthi bekukhulunywani ngoba kwakhona abantu ababezophenya lapha. Ngase ngithi mhlambe ukuze kufuna ngathi kufuna nginikeza bona ukuze mhlambe mabe kukhona abakutholayo ongaba mhlambe kusifake mhlambe ukuthi mhlambe iziboshwa zibaleke mabe kuthola basinikeze ukuze nami ngiqinise kakhulu ezokuphepha ngaphakathi.
Yebo.
Ngase nginikeza ke abaphenyi bayifake eplastikini elivalekayo bayisila sike basebethi bazohamba nayo ke.
Now, if you say you gave it to the investigators, who are you referring?
Ngikhuluma Colonel Gininda nabanye kayihamba nabo.
Do you remember with whom he was?
Mangikhumbula ngahle kwakhona omunye kuthiwa Mohani.
What type of phone was this?
Imnyama ibhalwe ukuthi style.
Now, did you personally know accused number 5 before this incident?
Ngiyamazi.
Have you had any interactions with him there?
Not ukuthi ukuhlanganisa ngokomsebenzi wami. Umboshwa mayifika ejele.
Yes.
Kufuneka mina njengomphathi ngimemukele ngimchazele ukuthi la kusetshenzwa kanjani usuku lokuvakasha kulunini isikhalo kusetshenziswa kanjani mawufuna ukubona umphathi. Lokho ngenza ukuthi ababoshwa abaningi thola ukuthi ngazi amagama abo naye ukuthi makukhuluma ngobani ngisuke ngazi ukuthi ubani umuntu.
Now, who is Busiso Yaka? He's the then head of Kalagabusha prison in Empangeni in KwaZulu-Natal. It's the state's case that accused number 5, Sfisokuhle Ntuli, was found with a cell phone while detained in the same prison in August 2020. The state has also led evidence that accused number 2, Bongani Ndanzi, was found with a phone in February 2021 at a Pretoria police station where he'd been detained. But the defense has denied the evidence by state witness Busiso Yaka.
Mr. Ntuli will also tell this court that when you entered inside the house and searched them together with Musawenkosi Ndimande, you recovered the cell phone from Mr. Ndimande's drawer, not a cell phone, but a charger from Mr. Musawenkosi Ndimande's drawer.
Anginakho lokho mina in my information.
And the person who was with you when you were searching them, when they were holding their hands up along the wall, recovered the cell phone next to the bed of Mr. Musawenkosi Nzimande.
Akulona iqiniso ke.
Did you obtain any statement from Mr. Musawenkosi Nzimande explaining as to where the cell phone was recovered from this room that you searched?
Singekudinga ukuthi statement kundimande because angitholanga lutho kuyo.
Were you alone as an official at that time when you were conducting the search?
Ngangingedwa ngoba kwaku late icon ma official ayisebenza lapho lesikhathi leso. Sasu 3.
Okay, what were the names of those 3? Of the other 2 if you were the third one?
Angisakhumbuli kodwa ngicabanga ukuthi mase sifune information ingatholakala.
Did they make any statements regarding the recovery of this cell phone in this particular room? Section 15B?
No, yimi nge statement because yimi ngathatha ifoni.
When did you make the statement you have referred to this court?
Ngasenza ngo-2023 if I recall after Pretoria High Court ayasicela.
Yeah, the dates in which you made the statement.
Ngasenza 23/08/8.
That is 30 August 2023.
Yeah.
Which is 3 years after the incident. Am I correct?
Yeah.
Why didn't you make the statement immediately after the incident, when the incident was still fresh in your mind?
Angithi ifoni ngayinikeza abapheni mabe ngafika bazofaka statement kimi hayi ukuthi ngalokho kwakusho ukuthi information seyilokhu seyindala information sekhona ngoba ngisaphila ngisekho.
In that statement of yours that we have referred this court to, did you write down the name of the other officials who were with you when you were conducting the search?
No, abhaliwe amagama lapho ngangiphendula imibuzo ayifuna umpheni ukuthi ngibhale statement. Mangaba ayifuna amagama ngizowathola ngumnikezi.
Did you write down the IME number or the serial number of the cell phone that you handed to them? By them I mean the investigating team.
Angithi le information IM number azange ivule ifoni. Kodwa serial number lenganikezwa ulokhuzana ubrigadier ayikuse plasticini yiyo lena ngayisebenzisayo.
The serial number you mentioned there is the sealback number.
That's correct.
How then can you prove before this court that it was the same cell phone number that you recovered from this room at Kalagabusha, the cell phone that you handed over to the police?
Yavala phambi kwami ngikhola ukuthi amaphoyisa akhona ayengakwenza ngoba ayivala ayisila phambi kwami aqhubeka nayo angikhola ukuthi amaphoyisa ayenza umsebenzi angakwenza ukuthi akusefuna because it was a black style and yiyo le sealed.
Accused number 2 denies that he was found in possession of a cell phone in the cells in Valeria. Otherwise, he would have long alerted his family that he had been arrested and where he's being held.
Akitselo nga soma fetulele mara ntelo nnete gore cell phone ona re fumane ka modisele.
And ironically, the person who received that call to say accused number 2 is sitting with a cell phone in the cells is not here to tell about that story.
Kamadimari horo itlan sala ka gore monna modimo ithobere tshebolo go bobolo ka se motho se ra mo itshwareke le nna ke na fetolewe.
Accused number 2 will also deny that that cell phone was found in him and it was sealed in the forensic bag in his presence.
Akimagale karo aona lo tsa dumelang ka moka mara cell phone re ikreile ka mo cell phone ka mo seleng ya ka ba ka ilwa ka la mo ka isela mo pela ka.
Both defense lawyers are slamming the evidence. The state is pushing for a conviction of the accused for the Meyiwa family to finally get justice. But this is just the tip of the iceberg. There's more damning evidence that we will unpack after the break. Stay with us. We're back with a blow-by-blow analysis of proceedings for the Meyiwa murder trial. Now, let's recap. Proceedings from last week saw cell phone-related evidence linking the accused to each other when the trial resumed after a 3-week break. A new layer was uncovered in the cell phone number that allegedly called Afropop sensation Kelly Khumalo before Meyiwa was killed. According to the data analyst Colonel Steyn, this number belongs to accused number 5, Fisoguhle Ntuli, but he denies this, saying it's not registered in his name. Now, another data analyst from the South African Police, Gideon Gous, told the court about how Ntuli is linked to this number.
Mr. Steyn, page 23, said, then my next point during my analysis, I discovered that Kelly Khumalo, with a number which she gives, she received a call from Ntuli Nkani with the number 073-305-9202. And he goes on to say it belongs to Sifo Kuhle. Then he continues on page 76, proceedings of 27 July 2023, line 9, says the start date of the call was 2 August 2014, and the time was 22:40, and the duration of the call was 110 seconds, close to 2 minutes. What is your comment regarding that number?
my lord. The number is found on the XTS, so some other time accused 5 must have given the number up on as a reference on the credit report. So it's exactly the same number that was told there.
The state's web of links doesn't just end there. Another number allegedly belonging to Fiso Guhlentuli is right at the center of the links and alleged to have contacted all the other accused. This number, analyzed by police officer Gideon Gous, was allegedly saved in accused number 2, Bongani Ntanzi's SIM card as Lungisani. But the defense challenged this.
Now, my instructions from accused number 2 is that he does indeed know this Lungisani person. And that Lungisani person is not accused number 5.
I can't comment on that. That's according to the database I received, and that's the analysis I've done.
Lungisani is not accused number 5, and the number attributed there that does not belong to accused number 5. He instructs me as follows, that they are allowed to make calls from the public phones at prison where he is accommodated. And he does speak to this person on this number on weekends when he's allowed to phone.
In respect of accused Mr. Mapisa and Mr. Ntuli, that's accused number 4 and 5, he says he knew them from a long time ago. They were communicating.
The start of the new week saw one of the investigators take the stand again. Sergeant Batumukhola arrested accused number 1 Muzi Sibia back in May 2020 for an unrelated case while investigations into Meyiwa's murder were underway. During cross-examination, the defense got to place an alternative version to what the state has been advancing in court. Sibia, through his lawyer Tulani Mgomezulu, says Meyiwa was shot by Zandi Khumalo's then-boyfriend Longwe Twala. He argues that the state's case was cooked to protect someone else.
According to the evidence that I have as a defense, he was shot when he was separating Longwe and Zandi, who were fighting. Longwe, when he came to Kelly Khumalo's house, he was drunk. He was in possession of a 38 special revolver. According to my witnesses, there were 3 shots that were fired, and there were 3 people that were injured as a result. Senzo was shot dead. Longwe shot himself on the leg in his ankle, and the other shot is the one that was fired on the floor. As a result, Zandi was injured. Do you have knowledge of it?
My lord, I do not have knowledge of what the counsel is putting in this court.
My lord, with the leave of the court, I just want to establish, but I know he is not Senzo Meyiwa, who cannot or will not be the witness of the state. I want to ascertain from my colleague whether he wants to use Senzo Meyiwa in the state case.
Mr. Baloyi, you say you have got a mystery witness.
I think my learned friend can just conduct his cross-examination. We have signaled our intention, my lord, that when the state case is closed, all the witnesses who would not have been called will be made available to the defense. I think it's for my friend now to put whatever version he wants to the witness.
You will remember that this case has 2 dockets, the one before court, Phosphorus Cas 636 and Phosphorus Cas 375. Docket 375 lists all the people who were in the house as suspects in the murder of Meyiwa and was investigated by Lieutenant Colonel Joyce Buthelezi and Mishak Makubo. No one has been charged and it is not before any court. Now, in support of this version, Mgomezulu pulled a statement from docket 375 deposed by Senzo Meyiwa's brother Senzo Meyiwa. The statement immediately raised questions about the Commissioner of Oath as the name isn't reflected on it. In it, Meyiwa talks about alleged utterances made by chairman of Orlando Pirates Football Club and renowned businessman Dr. Ivan Khoza.
I would like to state that Mr. Evan Khoza told me that Senzo Meyiwa my brother was not shot by robbers. These were the actual words of Mr. Evan Khoza. There were no intruders that were shot that entered the house. Senzo was shot by mistake. There was a fight between Uzandi and her boyfriend. This means that Senzo was never shot by the robbers, but he was shot by mistake, as there was a fight between Zandi and her boyfriend. I would like this matter to be investigated as to who told Mr. Evan Khoza, to be established as to who told Mr. Khoza this, as to what exactly happened in the house where my brother was killed. That is all I wish to state. I know and understand the contents of this statement. I have no objection in taking the prescribed oath. I consider the prescribed oath to be binding on my conscience.
Thank you, Madam.
As a court, please, my lord, in all fairness to Mr. Khoza, he has submitted a statement refuting these allegations. That statement was disclosed to the defense. I think it's improper, my lord, for my learned friend to put a version here before court that he knows has been refuted by the person to whom it's being attributed.
May I reply, my lord, by saying, I had a discussion with my colleague, Mr. Baloyi, and asked him about the outstanding witnesses so that we can properly prepare. There are certain witnesses that were given by Mr. Baloyi, but he did not mention Dr. Ivan Khoza amongst the witnesses that he is intending to call. I was told that he intends to call General Lishabane, whom we did not use during trial within a trial. I was told that he's going to call Kwabeni, continuation of the evidence of the ballistic, Mr. Mangena, another ballistic, but he never mentioned about Dr. Khoza.
No, but
it's my submission that...
I mean, now we're confusing the picture. This is a simple assertion made by the prosecutor, Mr. Baloyi.
Yes.
He says, what is contained in that statement?
Yes.
Of Mr. Sefiso.
Yes.
That's the brother to the late
Senzo Meyiwa.
Senzo.
Yes.
Has been refuted by
yes.
the very Mr. Ivan Khoza.
Correct.
That's what he's saying.
That's not
he says he's got a statement.
That's not the only way to
all
refute.
It. So that's what we're busy with. Okay.
But
so you may continue.
But the state says this amounts to triple hearsay and that Khoza disputed the contents of the statement. The version is not the only aspect that was challenged. The kind of gun used to take Meyiwa's life also came into question.
I'm putting to you as per my instruction and as per what I've gathered from the statements of these witnesses that the firearm that killed Senzo Meyiwa was not a 9mm, was a revolver special.
Kelly Khumalo remains one of the big talking points in this case. Mohula also confirmed that the state believes she is the mastermind behind Meyiwa's murder. But accused number 3, Mthobisi Mncube, says he doesn't know her and wouldn't know how Meyiwa was killed because he was not there. By Thursday, the state came for the accused alibi, revealing bank records depicting transactions made in Sibiya's Capitec account. Records show this took place in Johannesburg.
Transaction date 9 October 2014, ATM cash withdrawal, ATM Phosphorus 2, Phosphorus 09ZA, 100 Rand was withdrawn and balance 708 and 42. Posting date 9 October 2014. Transaction date 9 October 2014, ATM cash withdrawal fee 460, balance 703 and 82. 9 October 2014, posting date 9 October 2014, transaction date SMS notification fee 1 notification, 40 cents, balance 703 and 42 cents. 10 October 2014, posting date, transaction date 10 October 2014, prepaid purchase MTN minus 12, and then the balance 691.42. 11 October 2014, posting date, transaction date 11 October 2014, ATM cash withdrawal, ATM, Phosphorus Naledi, Phosphorus 097A. Amount of 100 rand was withdrawn, balance 591.42.
Sibiya previously told the court that he never set foot in Gauteng in 2014. In fact, he returned to KwaZulu-Natal in 2013 after losing his job and only came back in 2015. This blow to his alibi is not the first. The state previously led evidence that showed that he sat for his learner's license test twice in Johannesburg in 2014. Despite this, the defense remains steadfast that all this evidence was cooked and that the person who killed Senzo Meyiwa isn't in court. The state continues with its case. Let's go through all the latest evidence and testimony with legal analyst Mnisi. Mnisi, thank you so much for joining us on the program. I want us to start with the cell phone evidence that we heard over a week ago. We know that accused number 5, Fisoguhle Ntuli, has been denying that the cell phone linking himself with Kelly Khumalo belongs to him, but the state now bringing a new witness in the form of data analyst Gideon Gous, who says that this number, in fact, was used to register for accounts. Why was it important for the state to do this?
Well, it was important to show that there is some linkage to a cell phone that belongs to him, and there was a connection between him and Kelly Khumalo, although surprisingly, we've been talking about it for some time then. Why was there no further investigation to arrest Kelly Khumalo? But with that linkage, it's important to show that, as she's now stated to be one of the mastermind, one of the masterminds, it's important to show that linkage. However, I was hoping that they would give us more than just the fact that they were talking to each other, but maybe to get a content of their conversation, maybe by a text of a WhatsApp or an SMS. But it's important to show that there was some linkage, but where does it take us to without the content of the conversation?
Does it then make it circumstantial evidence, given the fact that you say, as you rightfully put it, we don't have the contents of that conversation? And what the defense is saying is that making a simple phone call does not prove any, wrongdoing.
I think you remember when Advocate Mshorelo was cross-examining one of the witnesses, she asked clearly that, is it a crime to call a person? So I think that is how the defense is going. That is their strategy, to say, okay, I can be calling that particular person or be called by that particular person, but it's not a crime. But as you've said, it's just, to a certain extent, it is circumstantial evidence. My take is it's suspicious, but for me, it ends there.
Let's talk now about the other number that links accused number 5 to all the other accused. Would the state then say this is in furtherance of their allegation that they all acted in common purpose?
There is that linkage, obviously, as it has been presented in court, that he could have been communicating with all 4 accused. But at the end of the day, I think there's more that is needed than just saying they know each other or they've been calling each other. That is why when this matter proceeds, I'm always, personally interested in what the people who are in the house are saying. But obviously, when we look at the evidence holistically, we're going to include everything, like whether the people who are charged were talking to each other. But as I've said in the first question is that calling each other may not necessarily be a crime, but it just puts us in a position to see that they have in fact been communicating amongst each other, they know each other. And if I'm not mistaken, you correct me here, Linda, I believe they did once say at a certain point in time when this matter started, that they don't know each other. So that just makes it clear that they know each other. And it's not necessarily helping their case when there are things that they say in the beginning and it's proven not to be so. However, at the end of the day, the charge is murder. And what we need is, have they murdered Senzo Meyiwa beyond reasonable doubts? And I think the state is trying to go to that point, but we'll see how far it goes.
This week we saw Sergeant Mohola take to the stand again. I know she was on the stand during the trial within a trial, but interesting that the defense now chooses to put their client's versions to her. Accused number one, you'll remember the initial version that he gave was that he was never in Gauteng in 2014. And now he also prefers to give the court an alternative version. I mean, there's only one version to the truth, right? What does this mean for his case, given that there's been a lot of developments, even with the bank records that we're seeing now?
It's important for any defense lawyer, preferably, or any person who's accused, that's what I want to say, to have a version that is clear on his defense, so that when it's challenged, it doesn't, raise suspicions, and it makes it very difficult to believe in what they're saying. Yes, the state must prove this case beyond reasonable doubt, but it's very important to have a very simplified version on your defense. So I think for example, you'll have a case where the accused will say he was at this certain place, but it's proven that he was not there. He was in fact in Gauteng. But at the end of the day, maybe he's not being clear, or he's evasive when he says where was he located when this murder occurred. But at the end of the day, it needs to be proven beyond reasonable doubt that he is the murderer at the end of the day. But it doesn't really help when your version, keeps on changing and it keeps on being challenged. It brings more questions. But as I say, at the end of the day, who made a Senzo Meyiwa is what we're trying to get in this case.
And his version, the alibi that he's given has suffered a blow twice. I mean, initially the state brought records from the eNatus system, and now they're bringing bank records that show that even in October, when Senzo Meyiwa was killed, there were transactions that were being performed in Vosloorus.
The alibi, it has to be rebutted by the state. All you do is to raise your alibi and say, this is where I was. But like I said in the beginning, or just before you asked this question, it becomes unfortunate for you as a defense or as an accused when you say something, but it's then rebutted, I think there's something that you need to ensure that when you prepare, you've got all your ducks in a row and you know exactly what you are saying, so that what you do as an accused, you challenge the evidence that the state is bringing, so that it doesn't look as if there's something that you are hiding. So it's unfortunate that he has raised an alibi and keeps been proving that he is actually not true what he's saying. So that's one of the things that when it's time for arguing, I'm very interested how they will argue out of that point. But at the end of the day, then we will see what other evidence the state has that links all the accused.
It's interesting because accused number 3 as well provided his version, and his sounds rather simple. He was not there. He does not know how Senzo Meyiwa died because he was simply not there. But he then goes on to challenge the firearm. You wouldn't know how Senzo Meyiwa was killed if you were not there. Why would you want to get into a space where you now debate and argue the issue of the firearm, especially when you have not challenged the evidence that has been brought by the state in the form of their ballistic expert? Talk to us about that.
Unfortunately, the firearm was found in his possession or where he stays. And I think the issue is he may say he was not there, but then he has to explain about the possession. Now, when it comes to the firearms, it becomes a highly technical issue because there are ballistic reports to prove that it is a firearm, it works, and at times the fingerprint has to be tested as well. Now, here is the very interesting angle that I wish it could have happened sooner, but I suppose in this case, Linda, as you've been following it for work purposes, it's going to take some time to be finalized. You need to be patient. The interesting part here is the defense wants to use their own ballistic experts, which is a great strategy because they are not ballistic experts. So they need someone who bring a different version compared to the expert that has testified, Mr. Magana. So I think when it comes to ballistic reports and expertise, it will help him to have that ballistic expert who will rebut what has been stated by the states. Obviously, we've discussed this where we say the witnesses are not necessarily experts. So when the firearm was collected, in however way they describe it, the people who collected the firearms are the ones who should believe more because they're the experts. But I'm interested what the ballistic experts for the defense will say. Obviously, there are financials that they have to arrange for that ballistic reports and for that ballistic expertise to come to court. But once that is there, I think that is where it will be clear how accused number 3's version will be assisted because he will need that ballistic report and the experts that is coming to rebut the ballistic reports of the states.
All right, and lastly, the issue around Kelly Khumalo. You don't see the state pushing it. It's always raised by the defense. The state has clearly said that they will not be calling her as a witness, and the defense said they might subpoena her to come. What is interesting about what the defense is doing is that Advocate Mnisi, who's representing accused number 3, said the allegations that there was a mastermind who then ordered the accused persons to kill Senzo Meyiwa is hogwash. These are just trumped up allegations. One then wonders where the defense places Kelly Khumalo. Is she a friend to them or is she an enemy? Because if you're going to say the allegations are trumped up against your client in Kelly Khumalo, then you're suggesting that the state could be wrong.
That is a very interesting strategy because at the same time, they want Kelly Khumalo to be arrested, which he has not been arrested at this point. But at the same time, the defense is also saying, no, this is a trumped up charge, and even the Kelly Khumalo scenario is not the truth. That is why Advocate Mngomezulu, he read out an affidavit or a statement by Senzo Meyiwa, the brother of Senzo Meyiwa, which is entirely different to what we've been hearing, because the strategy now is to say Longetswala was the one with the firearm. He shot at Senzo Meyiwa when there was a fight about certain issues that they had, and Kelly Khumalo is not involved in the planning or the killing of Senzo Meyiwa. And it leaves a question now, why even Longetswala has not been called to testify.
Legal analyst Melusi Xulu, thank you so much for your time. Well, join us again next week as we give you a roundup of all the details of that trial. Until next time, bye-bye.